Before we look at the classifications of statutes based on their objectives, it is very important for us to understand that a statute may have multiple objectives. For example, the Companies Act is a codifying statute. Some parts of it are also declaratory. It is also a consolidating statute because it consolidates some of the laws that preceded it. It prescribes some fines and penalties, so it also has some penal objectives. So most statutes will not neatly fit into any single category. They will come under multiple categories depending on the context. Codifying statutes codify unwritten laws in orderly and authoritative statements. For example, there were several customs and traditions that were historically being followed by various communities and groups of businessmen. If anyone broke such customs, then that person would be punished by banning him or her from trading with anyone else in that group. Now the Contract Act codified many such customs and traditions into an orderly and authoritative document. Declaratory, which are statutes that state or declare existing laws and not necessarily create new laws. For example, even before 2006, child marriage was already prohibited under different laws. However, these laws were not effectively implemented, and there was also some confusion regarding their application. So, the Prohibition of Child Marriage Act of 2006 provided clarity on the legal stance against child marriage. Remedial, curative, and validating statutes remedy or cure defects in existing laws without making substantial changes. They may also validate judge-made laws or judicial precedents by including them in the statutes. For example, the Companies Amendment Act of 2015 was introduced to simplify the procedures and remove some of the ambiguities in the previous Companies Act of 2013. The new 2015 Act provided several amendments to cure the defects and clarify the provisions of the older 2013 Act. Amending acts are similar to remedial, curative, or validating statutes because these are also making changes to existing statutes. But the crucial difference is in the scope or in the extent of the changes. While remedial statutes make small corrections or small changes, the amending statutes bring about significant changes. For example, the Information Technology Amendment Act of 2008 was an amendment to the Information Technology Act of 2000. The new act introduced changes to tackle new forms of cyber crimes, and it also included provisions for offenses like identity theft, cyber terrorism, and data protection that were not prevalent when the original IT Act was passed. Consolidating statutes consolidate multiple statutes or rules into a single statute. For example, even before 2016, people, firms, and companies were becoming bankrupt, but these situations were being handled under different laws in different ways. The Insolvency and Bankruptcy Code of 2016 brought together these fragmented laws related to insolvency and bankruptcy of corporate persons, partnership firms, and individuals into a single legislation. Enabling statutes remove restrictions or disabilities. They may make certain actions lawful. They may create new powers or permissions for individuals, organizations, or government bodies. For example, the original Constitution had right to property as a fundamental right, which meant that the state could not take over private property easily. The act or the statute to amend the Constitution to move the right to property from a fundamental right to a lesser constitutional right was an enabling statute, since it now enabled the government to take over private property more easily for public purposes. Many statutes have prohibitory, disabling, or restraining objectives. For example, the Child Labor Prohibition and Regulation Act of 1986 specifically prohibits children from being employed in several sectors or industries. Penal statutes like the Indian Penal Code specifically impose penalties, punishments, or forfeiture. Permissive statutes permit certain acts without making them mandatory. For example, the Right to Information Act grants citizens the right to access information that is under the control of public authorities. From a citizen's perspective, it is permissive because it allows citizens to seek information, but it does not make it mandatory. Like I mentioned earlier, the same statute can often be classified under different categories depending on the context. The RTI Act is a good example of this because from a citizen's perspective, the RTI Act is a permissive statute. But from the government authority's perspective, it is mostly a mandatory statute. Repealing statutes are laws that are enacted to revoke existing legislation, either in part or in whole. When a statute is repealed, it becomes invalid. But certain provisions, called the saving clause, may be included in the repealing statute or the new statute to preserve the actions that were taken under the old repealed law. A good example is the Repealing and Amending Act of 2019, which repealed 58 obsolete and irrelevant laws. Whenever a new act is passed on the same subject, it usually repeals the older act, partly or fully. If it is specifically written in the new statute that the old statute is repealed, it is called explicit repeal. If the new statute is so inconsistent with the old statute that both cannot reasonably coexist, then the older statute is automatically considered to be repealed, and this is implicit repeal.